Welcome everybody to this public meeting of the Dispute Resolution Committee on November the 12th. The meeting of the has been duly advertised as a public meeting in accordance with the Sunshine Act and is therefore open to the members of the public as observers. Bree, could you call the roll, please?
Yes. Tamar Alexander.
Good afternoon, everyone present.
Commissioner Kevin Boozle.
Present.
Stuart Fisk.
Present.
Shay Madden.
Yes, I'm on mute. I'm here.
Commissioner Robert Postal.
Here.
Senator Christine Tartaglione.
I think that she was going to be in session with the Senate this afternoon.
And Chair Tom Van Kirk.
Present. Okay, 6 of the 7 members are available. That is a quorum, so that we can proceed with the meeting. I would like to say that participation in the meeting is limited to representatives of the Berks County District Attorney's Office and the Bucks County District Attorney's Office, since they are the 2 counties or 2 entities that filed appeals that are going to be heard today. The meeting is being recorded, and the video will be available on the Trust website along with the minutes from this meeting once approved by the DRC. An executive session was held immediately prior to this public meeting for the purpose of receiving legal updates and legal advice. With that, could I have the minutes of the September 17th, 2025 DRC meeting? We're in your packet. Could I have a motion for their approval, please?
Motion to approve.
Second?
Second Postal.
All those in favor, please say aye.
Aye.
Opposed? Okay, the minutes of the September 17th, 2025 meeting have been approved. The first item on the agenda will be the appeal of the Berks County District Attorney concerning the Berks County District Attorney Program number 2, labeled as Intervention Toxicology Center. Could I ask who from Berks County is going to be on the phone and presenting?
Good afternoon. My name is Kenneth Kalisik. I will be the lead person presenting for Berks County with the District Attorney's Office. But I have a number of individuals here who are also going to be adding input into our appeal of the denial of the money for the Toxicology Center. Would you like their names, or would you like me to email them to your staff?
Why don't you go ahead and identify provide the names right now?
Directly to my right is Nicholas Volo, who is a probation officer with Berks County. To his right is John Adams, who is the DA of Berks County. Around the table to him is Brendan Harker from Adult Probation, who may or may not add additional testimony. And then to his right is Daisy Holston, who is with Task, the Toxicology Center in question. And seated behind Mr. Adams is the Honorable Lady Demetrio Geishauser, who is the head of our treatment courts, who use a lot of the testing in question here.
Great, thank you very much, and thank you all for being willing to participate this afternoon. With that, you can go ahead and start your presentation as to why you believe that the original opinion of the opioid trust, which voted to not allow this program, why they were in error, and this dispute resolution committee should overturn that decision.
Thank you very much. According to the email that we received June the 16th of this year, the reason this was denied was that the Toxicology Center may involve punitive action on behalf of the county against the individuals who have submitted to the drug testing. That's not how our county uses the drug testing and the task center where the testing is completed. The reason we use the testing center is for the purposes of a tool to determine whether or not individuals who are currently under supervision and participating in our courts, whether they are currently suffering from an opioid use disorder or a coexistent substance abuse disorder or mental health issue. The first person I'd like to have present some information, like I said, is Ms. Holston from Task, who is that center. Ms. Holston, can you explain to them what Task does a little bit so they have an idea of what we're dealing with?
Sure. TASK is the primary resource for individuals who are under supervision, as well who from adult probation, juvenile probation, children and youth, and also with another nonprofit agency, Connections Work. They come over and complete any required drug testing. We report the results back to the agency. We have no recommendation in any kind of regard to any punitive measures. In fact, we also recommend if they do test positive, that they return back to our facility for a complete DNA assessment. And then we also do recommendations for whether it be outpatient treatment, inpatient treatment, mental health treatment, as we also have case management at our facility, and accommodate those individuals to be able to access that particular treatment. We work collaboratively with all the agencies in assisting them with getting funding in order to be able to have that treatment if not deemed necessary. And the funds that are provided from this trust deeply help the individuals, as previously they were paying out of pocket for that testing. So they come in now to our facility and do not have to provide any financial means in order to access the testing.
Could I ask, what happens if somebody refuses to be tested?
We don't mandate them. We're not required to
Yeah.
make them do that. They come over with the referral to have it, even with the recommendations, if they are deemed appropriate for inpatient treatment. We do not force anyone into any kind of treatment or any punitive measures with that.
Okay, thank you.
But does the probation or does anyone else require that? Other than your agency? I understand you're the testing agency and you can make recommendations, but does someone else make the decision? And is the decision ever forced?
That would be,
I believe Mr. Volo would be able to answer that question. You can go.
So part of their terms and conditions of probation or parole to submit to urine screens on a regular basis. Obviously, if they have an underlying substance abuse, specifically for opiates, they are required to go to maybe twice a week urine screens, once a week urine screens, whatever the recommendation is. At the end of the day, our goal and our objective through the Berks County Probation Department is to exhaust all resources in the community before we potentially get to a short-term incarceration, which is then followed by a long-term of inpatient treatment. That is our goal. But to answer your question, if there is consistent refusal and it is part of their conditions of supervision, we may have to intervene, but we exhaust all resources before we get to the point of potential incarceration. I want to make that abundantly clear.
Thank you. One last question for you, sir. If I can't afford to pay, I'm indigent and it's a requirement of this program and I can't pay it, what happens to me then?
And that's a great question, because that brings back responsivity and barriers back on the individual on supervision. There is definitely a higher risk if they cannot attend. We don't know what they're using. Therefore, we potentially would have to get to the point of incarceration. Again, after a number of no-show. We're not doing that on the first no-show. We're not doing that on the second or third. We're working with them actively out in the community. But again, if we suspect that they are using and we don't have any evidence of that, we may have to intervene again with a short-term period of incarceration.
Could I ask for clarity on the commissioner's questioning? What if, not that they're not, it's that they can't afford the testing? So
Correct.
not that they're not showing, they can't afford the testing. What happens there?
Well, that's actually where the funding we're receiving.
Understood. Without this funding, what would happen if I present myself and I can't afford the testing?
Thank you.
Yeah, ultimately, again, that would result in potentially more violations and higher rates of incarceration, and we're trying to avoid that. That's our end key.
Thank you.
Couple things I just wanted to touch on. During Ms. Holston's statement, she talked about Connections Works that is what most people would refer to as our pretrial services program. Because the testing that is conducted through task, as a county, we're trying to get a quicker handle on the people that are coming into the criminal justice system to determine whether or not there is a underlying substance use disorder, because that doesn't always show up based upon the nature of why they're there. With pretrial services, there are times where someone comes in for a theft charge, which on its face would not appear to be a opioid use disorder. But we're finding that by testing them, we can find that the underlying cause of their other activity actually is a substance use disorder, and we can get them started with treatment much faster. Getting back to the last question, part of the funding that, or I should say, the funding we're using for this program allows our county to engage in cost-free urine testing for the people who are required of it. Harkening back to what we call here the bad old days, when we used to have to charge people for individual testing, you had people who were showing up, attempting to be tested, not having the money to do so. And in that case, a number of different things could occur. Sometimes it was placed on their underlying criminal bill, the costs that were associated with their prosecution. Other times they simply weren't tested. So the funding that we receive from the opioid board has been extremely valuable for the purposes of allowing not only the testing to occur, but just having a better quality of life for the individuals that we're supervising. I believe Mr. Volo has an additional statement he'd like to make in regards to the task center.
Okay,
Thank you. By alleviating the cost of drug screens for individuals, we reduce not only financial barriers, but also barriers to receiving appropriate treatment and services. This allows individuals to focus their finances on basic needs, therefore improving the quality of their life and addressing other barriers such as residency, mental health concerns, examples like such. Moreover, understanding the types of drugs being used, as well as the frequency and the amount of use through drug testing, can assist drug treatment providers in determining a proper level of care, whether that's inpatient, outpatient, intensive outpatient as well. Free drug testing further increases the likelihood that a person will comply with drug testing attendance and therefore receive appropriate services and treatment. Between October 1st, 2023 and September 1st, 2024, 12,686 drug screens were conducted by Treatment Access and Service Center for individuals under supervision in Berks County. Comparatively, 22,509 drug tests were completed between October 1st, 2024 and September 1st, 2025, following the implementation of free drug testing in September of 2024. This increase in testing has not led to a significant increase in violation, but has resulted in a higher amount of referrals for treatment following Gagnon 1 hearings. When individuals are complying with their drug screens, officers can address drug use based on swift, certain, and fair principles before the issues become more serious, which has shown positive outcomes in reducing recidivism, confinement, and further drug use. One thing I will point out, percentage of violations in Berks County, the highest percentage of violations are for Rule 1, which is failure to report as directed, simply an absconder. That comes in at 23% of the violations we have in Berks County. The second highest violations are for Rule 4, which are new arrest, and that's at 22%. Drug use is 10% or slightly under 10%. And again, when we take in consideration those individuals, again, we're temporarily incarcerating them. If we've exhausted all resources, the first goal is to accomplish everything in the community setting. That's our first goal. And we're not detaining them after the first, second, third, sometimes not even the fourth. Okay. It's ultimately when they become a risk to themselves or the communities when we intervene with short-term incarceration. Typically, that is around 2 to 6 weeks before they are incarcerated and actually into an inpatient treatment program, where they then will go to an inpatient program from 30 days, 45 or 60-day longer-term inpatient programs.
And those inpatient stays are after they have been offered that same option while still out in the community.
Correct.
We don't begin by saying you failed a single drug test and you are being incarcerated. It is you failed a drug test, what's going on? Trying to get into the person's life while they're still in the community without having to resort to incarceration. Even after a second or third failed drug test, incarceration is not the first choice. The first choice is treatment. And kind of what the goals of this trust are to do, to try to avoid incarcerating people for opioid use disorders or other substance abuse disorders with mental health issues. So that's what we're trying to do. The drug tests are the tool to get us there, with incarceration or punitive purposes only being a last resort after the person has shown themselves to be a danger. Additionally, as I stated when we got started, present is the Honorable Leni Demetrio Geishauser, who is the head of our treatment courts, where drug testing is an invaluable resource in all of our courts. And I believe Judge Geishauser can speak to how we use drug testing in those courts.
Good.
Good afternoon. Thank you for having me. As Mr. Kulisek said, I am the administrative head of the 4 treatment courts in Berks County, but I also preside over 3 of those 4 courts, being drug, mental health, and DUI. I have been in that role, at least presiding in a treatment court of some kind, for the length that I've been on the bench. It was part of my first assignment. And when I first came onto the bench, the clients had to pay for drug testing. And it was a very difficult road to hoe, because our focus in treatment court is treatment, is addressing their underlying substance use disorder. And when we have to add on to those things financial obligations, like their drug testing, it shifted their focus from concentrating on their substance use disorder to concentrating on making sure that they had employment, making sure that they could borrow money, all of those other things in order to pay for that drug testing. Now we can have them focused on that, because let me just give you a little background. Treatment court is a 5-phase program. The first phase of treatment court, really the first and second phase of treatment court, is alliance with your treatment provider. So what we're trying to do is really take away all of the other noise, worrying about a job, worrying about your home, all of those things we work on with the clients so that they can totally concentrate on their treatment. Now, your question probably will be, well, what happens while you're doing that if somebody tests positive? Well, I can tell you that people test positive all of the time in treatment court, because they come to me having had a substance use disorder, most for the better part of their life, and trauma on top of that. So we know going in that we are going to have positive tests. It's not about the test. It's about what happens next for our team. It's a team approach. We have approximately 10 to 15 people on our team who come together and make decisions as to what happens next. So in the case of a positive drug test, which, like I said, this is a regular occurrence for us, we first determine their level of substance abuse. If it's substance use severe, we determine the interventions that we have utilized to this point. We see what level of care they are at. We get input from their treatment provider. We increase their level of care. Sometimes we send them to more events in the community. We have a sober living house, so sometimes we change where they're living to a therapeutic environment. I can tell you with 100% certainty that jail is against the best practices for treatment courts as set forth by the National Association of Drug Court Professionals, which is called All Rise. So we never incarcerate upon a drug test. The first, the second, the third, the fourth. I've had clients go through inpatient treatment 3 or 4 times before we have to make an ultimate determination. And this is after probably 2 years of working with someone, that this isn't going to work. So I can tell you with 100% certainty that for us, the drug testing is a very valuable tool. It keeps our clients safe. It keeps their kids safe. It keeps their families safe. It keeps this community safe. And it allows my treatment court team to do the best job that they can and have a quick response to that participant's needs, because we get our results and then I can send probation to their homes to check on them. We can make sure if there's kids in that home that everyone is safe and that that client is receiving whatever care is necessary. So I can tell you that was a much harder job when they were paying for those tests. Now I never have someone come in and say to me, I didn't go to my test because I couldn't pay for it. We applaud honesty. They go to those tests even when they know that they are going to test positive, because they know that our response is going to be therapeutically generated. It is not going, they are not going to go to jail. They know that, which is why they show up to the test even when they know they're going to test positive.
Thank you, Your Honor. Could I ask just one follow-up question to that? Since you are the one that ends up reviewing and say, so 100% of the times when somebody tests positive, you put them into alternative treatment and it doesn't lead to incarceration. Is that correct?
I would say 100% of the time for the first, second, third, even fourth. And there's no one way to look at this because each client is different.
Right.
But I would tell you that the clients that struggle, I've had clients who have struggled through the treatment court process, who have been in treatment court for 2 years, sometimes 2.5 years. We do not give up easily.
Okay.
I do everything in my power. Sometimes I feel like it's by my own sheer will that I think I can drag them through and help them be successful. Myself and my team, we are highly invested in this program. We, in fact, have been recognized by the Pennsylvania Supreme Court as a champion court because of our adherence to the national best practices for treatment courts. So we take our job very serious, and we take our obligations to this community and to these individuals and what I'm promising them when they take their guilty plea, that we are going to help them very serious.
I think I saw the letter that Justice Probson sent, and he was a former partner of mine, and I know he doesn't do those things lightly. So congratulations on that.
Thank you. We're very proud of ourselves.
I did want to just touch on one thing the judge said.
Can I break in if I can?
Yeah, sure.
Mr. Chairman, Stewart has had his hand up for a while.
Okay. Sorry, Stuart.
Yeah, I try to be polite sometimes. So these are a couple of questions that I have. So first of all, let me just say that the clarifications you made today have been extremely helpful. And I think this is a lot of what we wanted to hear, and we wanted to hear it clearly. As a clinician, someone who's treated people with substance use disorders for many years, I used drug testing going way back when drug testing was not used in the way that you're describing, but I used it that way because it was the most helpful way to do toxicology for people, in the same way that we look at outcomes for blood pressure and cholesterol and blood sugar. We're looking for treatment outcomes and we're adjusting treatment based on that. We're not firing people. So it's a very similar kind of thing. So I appreciate hearing that. I do have a couple of maybe kind of geeky questions. What type of testing does TASC use? And there's a reason for me asking this. I'm not just being a nerd.
So we have a 10-panel test. We do the collection, and then AberHealth does the actual testing, and they report back to us.
And what's the technology they use? Is it just a urine like dip test or?
Yes.
Okay. Is there ever confirmatory testing done or further testing done?
If there's ever a client who disputes their test, we can always send for confirmation. We have that availability, and we have used that in the past.
Okay, and the opioid funds would be used for confirmatory testing as well?
Yes.
Okay. And then you're using a 10-panel test. Is that I've done a lot of work in the last couple of years about what's in our illicit drug supply, and it's getting kind of scary. I'm sure you've heard of xylazine, medetomidine, some of the other kind of drugs, and the fact that we're seeing samples of street drugs that have no opioid, no fentanyl, no nitazene, and no detectable methamphetamine or other drugs. Are you able to detect those things?
There are separate testing that, I believe the option is if we choose to pay for that, extra confirmation, it is available, but it's not currently on the panel that we utilize. As you're well aware that they can be quite expensive.
Yeah.
So if there's someone that is suspected of that, we can opt for those particular tests.
And I can just interject there. When you look at, for instance, the treatment court participants, their touch points with members of the system are several times a week, including in-home and community visits. So as soon as we get any indication that maybe something is going on or someone reports something, we adjust those panels to include what we're trying to see if that we might be dealing with.
Okay, thank you.
Anything else, Stuart? Other questions?
Yes, can I ask a couple things? Stuart, you covered some of mine, so thank you. So, and if you said this, I'm sorry, I missed it. If they couldn't pay before, they weren't drug tested?
That's always been an issue with our department historically. If they could not, right, exactly. If they could not afford the $7 or $6 for the urine screen, they were not actively being tested, which is a concern. For the individual on supervision, in addition to the community. And again, if we had a line of no-shows for, a month, 2 months, we don't know what's going on, but we suspect that there's substance abuse going on. Our hands get tied, and then we ultimately lead to incarceration, which again leads to higher rates of potential recidivism down the road.
And you answered my other question. I was gonna ask kind of the price of the cup that
Yep.
you're using. And just kind of as an FYI, there are 20 panel cups that are $6 or $7 a piece, and I'd be happy to provide that information.
Okay.
That's all.
Other
Thank you.
questions?
My questions have been asked and answered. Thank you, Mr. Chair.
Okay.
I want to touch on a couple points that were made. I'm the assistant district attorney who does sit, our mental health and veterans courts. And one of the things I did in preparation for this hearing was I went back and reviewed the last 90 days of mental health court lists that we received. During that 90 days, and we have roughly 25 people in mental health court. During that time period, we had 17 different times that individuals participating in the courts tested positive for a controlled substance that we were testing for. None of those 17 were incarcerated. They were referenced out for a greater level of care, or a couple of them who are currently in inpatient facilities, because when they were brought in and confronted, they agreed to go to treatment, and we were able to help them in the community without the need for incarceration. Additionally, and this goes to Mr. Fisk's question about the additional testing that can be done. Probably about 2 years ago in the Veterans Court, we realized that there was an issue with individuals who were utilizing ketamine. It was not one that we were typically testing for. An officer conducting a home visit saw evidence of ketamine. We then, because we had noticed some slipping in attendance of other aspects of the Veterans Court program from a number of participants, using the testing funds that are currently being used, we were then able to test for ketamine and found that we actually had 5 or 6 gentlemen who were using ketamine. And it allowed us to nip that issue fairly quickly, and get the 6 of them into a program that would help them. And in that, the only one who was ever incarcerated was the individual who happened to be selling ketamine, not just using it. And that actually ended up being a larger investigation where a partner was selling those things. So it was an issue of delivery of narcotics, not use, that got us there. I see that our time is running short. In reviewing your Exhibit E, Schedule B, we believe that the funds that we're using through this testing center comply with subsections D2, D3, and D5. dealing with pretrial services or treatment-based programs, as well as the people under supervision and the recently released from incarceration. Especially in regards to the recently released, we find that the testing is of utmost importance with them because you've been incarcerated and you're immediately released from jail. There's a tendency to slip back into old habits where that testing tends to keep people on the straight and narrow. So in closing, we believe that we've complied with the exhibits. I was going to say, Mr. Adams, do you have any statements you'd like to make?
I just in closing, we're here to help people. And when I got involved in this litigation and became a recipient of these funds, I concentrated on this population, the population in our probation and parole system. We want to change their criminogenic behaviors. We need to help them. Putting them in jail is not the answer. These funds have gone a long way in helping people, and I don't want to see us revert back. I want to see us continue to help this population who needs this drug testing so we can identify their issues, which led them to maybe commit or be involved with criminal behavior.
Great, thank you very much. Shay, do you have a question?
I do. One last one. I just want to make sure I am clear. And I do appreciate that you are, treatment first in a lot of the senses, but I do have one question. So I think you said there were like 24,000 tests done last year, roughly.
Yeah, 22,000, yep.
So what percentage of those individuals were sanctioned, punished, whatever word you want to use?
Yeah, that's a really good question. Actually, I could give you, it led to 314 Gagnon 1 violations, which were held, and 358 individuals were referred to inpatient treatment. So Gagnon 1 is the first step in a violation process. Gagnon 2 is ultimately when they get back before the court. So we avoided by going back before the court by putting them into longer term inpatient treatment.
And would they have gone to jail prior to that?
Potentially.
Okay.
But again, that's not our philosophy. Our goal is
No,
to
I
address
understand.
this. Yep.
Thank you.
Yep.
Okay. Any other questions? If you're done with the presentation, I'd like to ask for any discussion that the members of the board have to say, or of the dispute resolution committee, and then I will ask for a vote. But what discussion would members of the committee like to have? Hearing none, I think we're ready to move on to a vote as to whether to uphold or overturn the decision of the trust. I would like a motion resolved that the Dispute Resolution Committee of the Pennsylvania Opioid Trust hereby affirms the decision of the Board of Trustees that Berks County District Attorney Program Number 2 is not compliant with Exhibit E. To reiterate, a yes vote would maintain the current denial by the trust, whereas a no vote would reverse the decision by the trust that the program is not compliant with Exhibit E. Could I have a motion to that effect, please?
I'll make a motion to get it on the floor.
Thank you, Rob. Could I have a second?
Second, Stuart.
Thank you, Stuart. Any discussion? Okay. All those voting yes to affirm, please say aye.
Aye.
Aye as well.
Okay, and all those that are that would maintain, whereas all that would vote no to reverse the decision of the trust, please say no.
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 No, Kevin Boozle.
And I do not have a vote unless there's a tie. The noes have it, and therefore the decision of the trust is reversed and the program is deemed to be compliant. Thank you very much to all of those who presented on behalf of Berks County for making a very, very good presentation. Thank you.
Thank you.
Thank you.
Okay, Bree, do you want to have the people from Bucks?
Sure. Can the representatives from Bucks County and Bucks County District Attorney please introduce yourself as well as provide your title?
Niels Erickson, Chief Public Defender for Bucks County.
And I'm Krista Dunleavy, Senior Chief Deputy Public Defender for Bucks County. And I just would like to make clear that the Bucks County District Attorney's Office is not appealing the decision, only the Bucks County Public Defender's Office is.
But the program was submitted pursuant to a program that was submitted by the district attorney. It was the district attorney's office who received the funds. So we're deeming this to be something that was a program submitted by the Bucks district attorney. However, you answered what my first question was going to be. The actual program that was submitted was both for another district attorney plus another public defender. And I wanted to be sure that all that is being appealed is our denial of the public defender position.
That's correct.
That's
Okay.
correct.
Thank you. Okay. Would you like to go ahead with the presentation in that case?
Sure. Thank you. Thank you for the opportunity to present this. I want to start with our clients and a general theme that the resolution of their legal trauma is often as important as the resolution of their physical trauma. The physical trauma affects their need, their addiction, but unresolved legal issues drive a sense of hopelessness. It drives their self-worth. It drives their employment issues. It drives their custody issues. And unresolving them is what leads to, in part, relapse from opioids. And I think the trust recognizes this under Schedule B of approved uses. Section D addressed the needs of the criminal justice involved person. And if you read Section D, it reads in part like a public defender job description. Support diversion and deflection from the criminal justice system. That's what public defenders do. Support pretrial services. That's what public defenders do. Support treatment and recovery courts. That's what the main goal of the public defender is in getting many of these opioid clients into treatment and recovery courts. Find services for recovery. Again, that's what public defenders do. Teaching law enforcement, correction, and judicial services on the needs of clients and services available. Again, that's the job of a public defender, to provide mitigation strategies to the court, to the district attorney, to law enforcement. Section D, or subsection D of Schedule B, is essentially a job description for a public defender. Now, I know that the denial was based on the language in the FAQ, in that services of a public defender are required to be provided by counties. Costs are not an abatement strategy. That was the reason for the denial. We disagree with that. We disagree with that on a number of reasons. First, we believe it reads a requirement into Section E that's not listed in Section E. Again, my expertise in Section E is not going to be as extensive as yours, but there's nothing in Section E that prohibits costs when the county already pays costs of that position. I know that this committee reviewed the Chester County District Attorney position, I think back in September. And the issue there was whether or not it was prosecutorial discretion, not whether or not the county was providing the services for the district attorney position. So we disagree that with the FAQ language that the public defender is required by the county to provide services. And I don't need to tell, I'm sure, anybody on this panel that public defender offices are chronically underfunded compared to law enforcement agencies, compared to probation departments, compared to district attorneys' offices. We are barely keeping our head above water. I want to start with talk about the role of the public defender's office with opioid clients. And it begins with the initial interview. We have a holistic interview method that we use here in the public defender's office. It's not just what are you charged with, what are you facing? It is what are your needs? What services have you been provided before? What addiction issues do you have? What services can we get you now? From the very beginning, we are looking towards mitigation strategies for their opioid use. We are looking at finding ways to get them in the services. How can we help the client's needs? How can we help them with treatment? Now, we do have a social services advocate position that was an accepted use by this, but the social services advocate works at the direction of the public defender handling the case. And so it's a little inconsistent that the social services advocate is okay to find services for the client, to find treatment for the client, but the public defender that is instructing the social services advocate is not an accepted use. All of it centers around the trust that the public defender builds with the client, and that's critical. You can have all the assessments permitted. You can have all of the treatment courts permitted. You can have all the recovery courts. You can have all the services available. And unless that client is listening to and trusting the advice of the public defender representing him, you're not going to get the use out of it that you otherwise could. And so I think that trust component between a public defender and between a client suffering from an opioid disorder is extremely critical in resolving not only their legal issues, but also their treatment issues. And the relationship between the two is extremely important. I want to start with, and in our documents, I know that a lot of the documents that we submitted were from the public defender's office, but the last 4 pages of the documents were basically the description and what the public defender does in this case. From the very beginning, from the moment they're arrested, addressing bail conditions. Can we get them into a treatment provider that will release them from custody? Can we get them into therapy? Can we get them into a detox? Can we get them into a rehab? From the very beginning, from the moment of bail, that continues at the preliminary hearing. Can we get them into a treatment program that will divert them from the court system? Can we get them into DCDP? Can we work with the district attorney with coming up with a mitigation plan that if we get them services in place, can that help alleviate their legal consequences? We begin building mitigation and services needed for the client and working with the client in providing mitigation from the very beginning of the case. And that covers all the way through, including whether or not they should apply for a recovery court, whether or not they should go to treatment court, whether or not they should stay with a treatment provider, and that will be sufficient to help them in both of their recovery and in both of their legal situation. The public defender's office is among the best to determine what the client's needs are because the client tends to be more open, not always, but tends to be more open with the public defender as far as what has caused their addiction relapse. What do they need help with? And then providing those services through the use of the social services advocate. So that's essentially, we laid it all out in our documentation as far as all the roles that we have. We are in treatment court, veterans court, we are in recovery court, mental health court, DCDP court. Every one of those courts, we are there providing services and providing help to the clients, helping them with legal issues that prevent them from relapsing, that prevent them from failing, that help and encourage their recovery. And for those reasons, we believe that the funding for the public defender's position is appropriate under Schedule E and Section B.
And do you have others that want to speak? Do you have others that want to speak? I'm sorry.
Krista, is there anything that you wanted to add?
The only thing that I would add is I would just point to Schedule B number 5, and that just specifically states provide community support services, including social and legal services to assist in deinstitutionalizing persons with opioid use disorder and any co-occurring disorders or conditions. And that, I mean, that is literally what we do every single day. We help our clients who are in the community with, once we have helped them to get treatment, we help them with barriers to treatment, like with transportation. You know, we work with Danny's Ride. I'm sure that you guys are familiar with that, in order to help our clients get to treatment, get to, you know, whatever they need to take care of. We also do expungements, and I'm sure you are aware that, you know, one of the best things for a lot of our clients is to be living productive lives, which includes working, and a prior criminal record can be an enormous barrier. And we help with expungements and helping our clients to clear their records so that they can live productive and healthy lives. Same thing with like abating court costs. We also represent people in the community who are released on probation and parole, who oftentimes are facing violations of that due to relapse. And again, at those hearings, our main focus is to assist our clients with accessing and participating in and following up with treatment. And I think that the B5 is it contemplates legal services, and who better to help people people in the community with their legal issues than a public defender. And I just think that very specifically authorizes the payment of the public defender position with these funds.
Thank you. Okay, are there questions of either of the presenters?
Hey, this is Commissioner Kevin Boozle, if I may. Can you hear me okay?
Yes.
Yes.
Thank you. Just a couple of questions, and I know I don't want to be snarky, but I have to ask this question. As a county commissioner, I fund the PD's office, and we fund ours pretty well. My question is this. I know we have mental health court, drug and alcohol court, mental health court. I don't have any veterans organizations or associations funding my PD, nor do I have people in mental health funding my PD. That is an expected cost of county government to expedite that. Nor do I think that it's anything extraordinary, as far as I can tell, from a public defender's point of view, to be able to find resources. You're right. I 100% agree. That is part of that role. I guess for me, when somebody pointed out, I'm sorry, I don't know the lady's name, that pointed out that legal services, and I think that what they're referring to is an extraordinary legal service where they have an extensive background. They're trying to get expungements. They're trying to get jobs. I think of neighborhood legal services in my area or something like that. It's not something that I would ask my PD's office to do, but that's kind of where my head goes when I hear that. So my question is, do you have funding for mental health or veterans for your PDs that is separate and extraordinary services that go beyond what you would normally do as a PD in any of criminal cases? Like, I'm just trying to put a pin in something that you said, and I'm struggling with it. So if you can help me with that, that would be great.
If your question is, do we have additional funding? No, but if your question is, are we expected as time goes on to do more and more with community and the client? The answer is absolutely yes. The more county programs, drug and alcohol treatment, that are created, the more coverage we need for public defenders to be involved in those programs and to advise our clients in those programs. We are looking for funding in any source that we can. That we have a prison probation grant that we're looking at as far as putting a funding in place for an attorney. But what is being asked of the public defender's office is more than what used to be asked, which is, here's the case, go try the case. We keep a database of treatment providers. We put them in touch with those providers. We fill a lot of the gaps from when a client comes in to providing services to them. We are the ones that are in communication with the service providers to give the client those services for treatment. And that is a difference that has happened over the past 10, 15 years as we go on, and as there are more programs and more funding available for providers. Our requirements and our job has become more extensive. If that answers your question.
And
It does, and it sounds like you have some extraordinary requests, right? Like extraordinary circumstances, as opposed to what you used to do, like you said, go try the case.
Correct. It's not
and
that simple anymore.
Correct, and I agree, and I think that's where the services have come in. We have a legal service advisor, a social service worker in our PD's office, I think 16 hours a week now, that does specifically those things. I guess that's where I'm thinking, why is that connection not being made with the SCAs, and why are they not making these referrals and working with the PD? I'm struggling with that because it's out. You're right. It's outside the scope of what you were hired to do.
I would
and I
suggest
think-
that 16 hours
Yeah.
is entirely too little time for a social services advocate to really assist the clients.
Well, that's in your case, not in our case. I'm just telling you what we do. You're right.
And if I may just point out two things, our office has an expungement unit, and our office actively assists our clients in cleaning up their criminal records. That's number one. And number two, I think I've been a public defender since the 1990s. And as Neil said, the job has changed, and the job has changed because of addiction. And the job has changed because 99% of our clients have either an OUD or another SUD or a mental health condition. And it is so prevalent now, and it never was before. And if, I don't know what the numbers are exactly, but I would say approximately 90% of our clients ultimately enter guilty pleas to something. So what we're doing then is not just trying the case, but we're working with our clients in order to present what we call mitigation, which is to say to the judge, here is the treatment that our client has become involved in. Here is how he's doing in that treatment. And here is why you should allow him to remain in the community so that he can continue to participate in this treatment. So the focus of our job has changed because the nature of our clients has changed. And that is the result of the opioid epidemic. There's no question about that.
If I can break in then, Mr.
Yeah,
Chairman.
Rob.
This is Commissioner Postal from Mifflin County. When I read the minutes of the salary board, is it that this is a new position that has been created with this?
Yes, sir.
That we created a new position.
Yes, sir.
Okay. And I believe somewhere else, and maybe it was in the salary board minutes, that the position would not exist without settlement funds.
That's correct.
I
Yes.
can chime in on that as the chief operating officer for the county of Bucks. Two things I want to say. One, this administration that's here now inherited quite a deficit from the previous administration, and we're still trying to dig out of that. And as part of that, we've tasked our folks to look for opportunities and funding to support each of their departments. And this is one way that we saw that we could bridge that gap, just ever so slightly. And we appreciate the board and their reconsideration of this, because it is truly needed in the public defender's office, this and so much more. So I just wanted to make note of that. And if you have any questions about our budget, I'm happy to provide guidance on that.
No, I'm happy I don't have your budget.
Yeah.
But I did want to make clear that the commissioners would not invent it, but would not start this position without the settlement funds. There would be other uses of their money, right?
Yeah. Yes.
So this is a new position. All right, thank you.
I have one question with regard to, as a follow-up to what Rob was asking. Since this is a newly created position, and I also read the minutes of the July 2022 meeting where it was approved, is the position restricted to assisting opioid use, OUD involved clients, or can it be used to represent whoever may come along to be represented by the public defender's office?
It can be restricted to opioid use clients. I would suggest that the majority of our clients are opioid dependent clients. But yes, it can be restricted to opioid use clients.
but it hasn't been as of yet. As of now, the person filling that position represents OUD as well as other criminal charges.
Yes, but that other criminal charges I would suggest is extremely small. That the majority, if not almost all of it, is OUD.
Well, is it I'm sorry, but this does become important. Is it a majority or is it almost all?
I would say if majority, if we're going to use that definition, yes.
And like
But
I
to
said,
answer to answer your question, that there are cases that get through that are not OUD, but that those are not a significant amount. Krista?
I was just going to say that 99% of our clients suffer either OUD or a co-occurring SUD and or mental health condition. It's just by far the overwhelming majority.
Thank you for that clarification.
Yeah, I think though that you opened up a question that I didn't think was going to be there. I don't want to be naive. Mifflin County doesn't have the cases that Bucks County has, and we would in no way be able to support a position like this, even partially. I mean, we don't with our settlement money, but I think there's a difference that the chair was trying to determine, and that is it a position for OUD clients, or are there others perhaps in the office that can also do this? I mean, is the budget for one person, or is it for the people that are actually working with the clients?
No, the budget is for one person. We have a dedicated diversion attorney whose job is to shepherd people through the different programs that are available in the county. Now, have there been on occasion where that attorney, because of staffing issues, because of other responsibilities, will go do preliminary hearings? Sure. Has there been situations where that attorney may be doing office interviews with non-OUD? Sure. But there is a dedicated diversionary court attorney whose job it is to handle OUD cases through the diversionary process.
Stuart's being polite again.
Yes, Stuart.
Yeah. Yeah, it's just the way my mom raised me. Not really. She would contest that. What I'm struggling with is I'm a retired nurse practitioner and spent decades working with this population of people, including people with HIV, addiction, and mental health and other kind of social issues. Very complex patient population. I also developed a lot of clinical programs for that population because I know how difficult the people you're working with can be, and not as humans, but just complex people with complex problems. And so one of the things that I've always done is insist on practicing in a multidisciplinary team. And we do that a lot in medicine because I can't do everything. I have very specialized knowledge in infectious disease, HIV, and addiction medicine. I have a broad knowledge about primary care, but I was never trained in surgery. So if I think a patient needs surgery, I need a surgical consult to tell me if in fact that patient does need surgery or not. It doesn't make sense for me to hire a surgeon to be in clinic all the time to do that work, right? So my question is, would it not make sense to hire people, and however many you need, whether it's 16 hours or 40 hours or 80 hours, that have specialized training in substance use disorder and addiction medicine and, levels of care and all that, to really be there as consultants to your public defenders so they can focus on what they've been trained to do, which is practice law and defend people.
Well, we do have a social services advocate who will scour for different services that are available. But they work closely with the public defender, such as, hey, there's a housing issue. He can't go back home because of an incident with his wife or his children. I need you to get me in touch with a housing specialist, so to speak. Or there are two issues. There's both mental health and there's drug and alcohol. I need you to find me a specialist that will work in both. And then following up with that social services advocate, hey, have you heard from Mr. or Mrs. So-and-so? Are they doing what they're supposed to be doing? Are they making their treatment plans? Is there some contact that we need to get on board and talk to them more about how important this is before they go in front of probation and parole, before they go in front of a court? So we do have that conduit, so to speak, but that conduit is supervised by the attorney that has the client's best interest in both the legal issues as well as their recovery as well, working with them for what they need. If that answers your question.
And why is that not enough? I mean, do you not have enough of those kind of people, or I'm just
The
and
it's because
it's just not because I don't work in your
yeah.
world, and I haven't. So these are questions that I think I just need to understand because I'm on the
I was in an hour-long prison board meeting this afternoon in which the main focus was a new drug, metatadine, or however you say it.
Melatonin.
Correct. That they're now getting rid of the xylazine, and now we're having to deal with this. It is constant, the amount of changes and drug needs that are out there for our clients, and their needs are changing constantly based on what their addictions are. Nobody's using heroin anymore. It's all variations of fentanyl mixed with veterinary drugs. And that has changed from where it was 6 months ago, which has changed from where it was a year or two ago. We need help in getting our client services and helping our clients through the legal system. And it constantly changes.
Okay, no, I understand. That's why I'm asking is that person really need to be a public defender? Or can you use the funding for public defenders to do their work, use opioid settlement funds to provide that ancillary social and legal services that are clearly allowable under Exhibit E?
Well, one of the other things that benefits of a public defender sometimes is because there is so much funding for these other treatment courts and other treatment programs. There is a tendency to over prescribe something that may not be wonderful for the client's needs. There is a wonderful treatment program that is 5 years in length. And what we're finding is that if we don't have the client motivated to go into this wonderful treatment program that is 5 years in length, the client will immediately fail out within a year or two. So it's not it's a function of getting the public defender to work with the client for the services that are most appropriate for the client's needs, if I'm making sense with that. It's not, can we get 5 more services providers out there available? But at some point, you have to match what the client's needs and expectations are and what their abilities are with what providers are out there.
Yeah, I don't disagree. My question really is just, are your public defenders the best people to do that work? Are there other people that really should be doing that work alongside in the public defender's department? I'll let Shay jump up because she's had her hand up.
Just to make sure I have the right assumption, you are working, your office does work with your SCA, the Bucks County
Yes.
Drug and Alcohol Commission. Okay.
Oh, that too. Yes,
Yeah.
absolutely.
Okay, thank you.
Yeah, we have, in fact, thank God they're there. I can't tell you the number of times that sending people down for an immediate assessment has saved them from going to jail. And again, it's because the attorney realizes the issue and gets them to get the assessment.
Diane, do you want to talk about what the holistic approach is here?
Diane Rosati?
Yes, Diane Rosati.
Okay, hi. I'll be very brief. Shay, thanks for calling out the SEA. I really appreciate that. We're sort of at once with that. So we so appreciate the partnership that we have. I just wanted, if you don't mind, to take 1 minute to share that we've launched a new program that I think is going to keep them even busier. Aside from the problem-solving courts, as you know, we've launched a new program at the Justice Center to try and help people to not end up at the jail for sure, but to help them early on in their substance use and in their addiction. So residents can have, through our office at the Justice Center, an immediate drug and alcohol assessment when they have a court proceeding. So we've trained the judges and the courts, and one of our biggest referral sources happens to be the public defender's office, because they see what you've all seen, which is they want to help folks in as early as possible to get access to services. So through the partnership, we can provide the free drug and alcohol assessment, free transportation through Danny's Ride, also funded through opioid settlement. So it's sort of a great story of how we can help together when we sort of, that spider web prophecy there, we can kind of get to folks earlier on and make sure that they get access to services earlier. So through Human Services, we've got sort of this one-stop shopping. We're a covered entity. We make sure that we share all good information about folks. And certainly one of our biggest partners is the public defenders through Niels, and certainly through Christy, who has been working tirelessly for years since these projects have started. And it's just a great partnership, but again, underfunded, and we won't be able to make this happen without these funds. So I just want to say again, as Margie McEvitt said, thank you so much for your reconsideration.
Thank you. Okay, other questions? Yeah, I can't tell if anybody has their hand up or not. Is anybody's hand up?
No,
Thank you.
you look clear, Mr. Chairman.
Okay. Okay, well, listen, thank you very much for the presentation. Are there discussion among members of the resolution committee? I think we're ready to make a decision. Okay, I am going to modify the motion that I normally make and have made at every other presentation, that being that that yes, a yes vote constitutes an affirmation of the original decision of the entire trust. But a no vote in this case, I would like to suggest, would be that we're not reversing, but rather we are sending it back to the entire trust for their further consideration of the issue. And the reason for that is we have in the past denied a lot of public defender requests. I don't feel comfortable, given the fact that we have denied a number of them, if the majority of this group decides that it would like to reverse the decision of the trust in this case, I think it is something that ought to be considered by all 13 members of the trust and not just the 6 people that are present on this call. So I will make the resolution or ask for a resolution that the Dispute Resolution Committee of the trust hereby affirms the decision of the Board of Trustees that the Bucks County District Attorney Program number 2 is not compliant with Exhibit E. A yes vote would maintain the current denial by the trust, whereas a no vote would indicate that it be referred back to the entire trust with a recommendation by this group that the entire trust vote that this program is in compliance. I want to ask legal counsel, is that permissible for me to do that?
Mr. Chair, can I make a recommendation? We go into a quick executive session?
You may. Okay, anybody else? We will go to executive session and then we'll get back on the phone in within 10 minutes with the final decision, okay?
Thank you.
Okay, thank you. Yeah, Bucks County back on.
Yes.
Yes.
Okay.
Yes.
No, parts of us.
Could I ask one clarifying question before, because we were having a discussion, Chris? When you said 99% of the cases that are handled are OUD, SUD related, did you mean for the entire office or for this particular position?
For both. It's the way that things are now. I would say the overwhelming, like high 90s% of all clients of the Bucks County Public Defender's Office have either OUD or a co-occurring SUD and or a mental health condition.
Okay, thank you.
And I cannot think of the last time that I represented somebody or came across somebody through my work who did not have any of those conditions.
I guess I could ask the question in that case, why are you only requesting the reimbursement for one of those public defenders?
What we would, I mean, if you want us to request more, we most certainly.
I would prefer you not, obviously, because I don't think it would be permissible to fund the entire public defender's office out of this, out of the opioid funds, frankly.
I would agree with that, sir.
Okay, thank you. Okay, the other question I have, Neil, and I guess you're the one as the primary presenter. If we were to, would you be willing to extend the time for us to make a decision on this case? As you know, we have 60 days, the trust has 60 days to hear your appeal to the Dispute Resolution Committee and make the decision. If we were to desire additional time so that we could refer this back to the entire trust to make the decision, as opposed to just 6 of us making it, would you be willing to grant us an extension of time to, let's say, December the 11th to make the final decision on this without being able to invoke that we had exceeded our time requirements?
Absolutely. I'm assuming I do another presentation in front of the whole board at that time, or?
We haven't even discussed what exactly.
The answer to your question is yes, absolutely.
Yeah. Okay.
Absolutely.
Okay. With that, since you did agree to extend it, we will vote.
There's a hand up, Mr. Chairman. There's a hand.
But just for a second, full point of information.
Absolutely.
With that extension, given that'll go back to the main board, does the county then have an opportunity to appeal that decision if they don't agree with it? It may be a question for legal. For the
You mean without going back through the Dispute Resolution Committee?
Would they have an opportunity to appeal whatever decision is made at the entire board meeting back through the DRC?
Me to answer that, or?
Yeah, it was a question for legal. It was a question for Jason.
We wouldn't be able to if we're only getting an extension of time to December the 11th, because that's for the entire appeal period. So it would be my thought that whatever the entire trust decides would be the final decision from which their appeal would be to the Commonwealth Court, not to this committee.
Okay, that was my question, just to make sure we were asking for the right amount of time. Okay, thank you.
Can I ask a clarifying question? So when you convene your entire board, and I think this is just a reclarification of what Niels had asked, will he represent to the remaining board members?
I don't know if it'll be necessary for him to represent or for just a presentation to be made whereby we will be summarizing. What the actual process will be, Chris, will be, I will go first to a working group. The working group will meet. I'd be happy to extend the opportunity for Neil to present to that working group, and the working group will make a recommendation to the entire board.
Okay.
So the entire board will be aware of what your position is, okay?
Okay.
Any other clarifying questions? With that, I given a possible resolution, and I would like to modify that to modify the resolution so that the resolution I'm asking for a vote on is resolved. The Dispute Resolution Committee of the Trust affirms the decision of the Board of Trustees that Bucks County District Attorney Program Number 2 is not compliant with Exhibit E. A yes vote would maintain the current denial, whereas a no vote would reverse the decision by the trust until the entire trust has the opportunity at its December 4th meeting to rule whether or not the program is compliant or non-compliant. So for your information, how that differs from what I read before was it's not going from us with any recommendation if people vote no, okay? Any discussion of that? Could I have a resolution to that effect?
So moved, Kevin Boozle.
Second it,
Kevin.
Tamar Alexander.
Thank you. Any further discussion?
I'm questioning the date that you just said, if it's part of the resolution. Are we sure of that? I don't have my calendar in front
The
of me.
public meeting is on December the 4th, yes.
Okay, all right.
And that gives us an extra week after that to get back to them with the final decision.
Okay.
Other discussion? Okay, all those in favor or voting yes, please say aye.
Aye.
All those voting no, so that it will go back to the entire trust, please say no. Please say no.
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 Okay, the noes have it. Therefore, we'll go back with the understanding that we do have the extension of time from Chester County. Anything else to come before this meeting?
Thank you. Just so I'm clear, someone will be in touch with myself or Shannon Kirby or to say, hey, this is what we need you to do on X date and time.
Absolutely.
Okay, great. Thank you so much.
And by the way, that may include the representation that 100% of the position that is being funded is going to be involved with representing OUD or SUD.
Understood.
Okay.
Thank you very much for your time.
Thank you all for your time and
Yes,
for a
thanks,
very
Sarah.
good presentation.
Thank you.
Thank you all.
Have a great day.
Bye.